Hello everybody, we are here again for part 2 of the documents that were filed on October 23rd. They just came out today. I'm gonna wait for a few people to get here. Okay, I just want to give a little bit of a warning at the very beginning of this video. This particular document is long and it is about an evidentiary rule called hearsay. And if you don't have a lot of legal knowledge or background, it may be a little bit complicated to understand, but I think you should still stick around and still listen. But I do just want to give that note, that, disclaimer, because if it feels like, oh God, this is so complicated, I don't understand this or something like that, that's totally fine. I personally myself only just learned about the hearsay rule when I was studying for the bar, and I don't have that great of an understanding either. So I am hoping that there will be other lawyers and legal professionals in this particular live to help fill in the blanks where I am undoubtedly going to not know some things. Okay, so just bear with me and we will, hopefully at least be able to get something out of this. This document is, it was filed by, the last document we read was filed by Britney's lawyer, Sam Ingham. This particular document that we are about to read is a brief. And a brief is something that lawyers write to a court to kind of make their argument. And this particular brief was written by Jamie's lawyers, and so therefore it would be coming from this perspective of Jamie. So we are going to be going over this particular document called Conservator James P. Spears brief regarding applicability of hearsay rule to Conservatee's out-of-court statements. So, hearsay is a particular designation that is given to certain types of affirmative statements. Now, the statements have to be, made out of court, and in order to be considered hearsay, those statements have to be being used in court in order to prove the truth of the matter that those actual statements say. So let's say that we're sitting on a park bench and I say, my mom lives in Louisiana, right? And then later in court, somebody says, I heard that surprise witness say her mom lived in Louisiana the other day. That particular statement is considered hearsay. Hearsay is inadmissible, which means it cannot be admitted into court unless there's a certain exception that may apply, right? And as you might imagine, there's a billion exceptions. And for the most part, if people want to get a statement in, you can usually get it in. So you have all these formal rules, but then you have all these exceptions. And usually you can get in what otherwise would be hearsay and therefore inadmissible. You usually can get it in through one of these hearsay exceptions. So that's what the subject of this particular very long document is going to be. And if that seems confusing, that's because it is. But let's just, give it a go. So this is written by, James's lawyers. And he's basically writing this brief to have the court read it. Because in the third document that they filed, this is the second one that we're reading today. The third document, which we will get to after this document, they filed something else. In that document, they're asking the judge to make a specific type of determination based on what they say in this brief that we're about to read, okay? So they're using what we're about to read, as supporting documentation for the third document that we will eventually get to after this one. So let's get started with this one. Now they have a table of contents, which you always want to kind of briefly look over just because it gives you a sort of roadmap to what they're going to be talking about. So their introduction, they're going to say that Sam Ingham's unverified statements, attributing statements to Britney are not admissible, and they are what's called double hearsay, which is, if hearsay isn't confusing enough, sometimes you can have hearsay within hearsay where, maybe someone wrote in their diary about me saying that my mom lives in Louisiana. Well, now someone wants to bring in my mom lives in Louisiana as a statement. Well, then someone else already wrote it in their diary. So that's hearsay as well. So now it's double hearsay. So they're saying in some way, Sam Ingham is committing double hearsay. They're all, and if you don't understand that, good, because me neither. We'll get to it in their argument. We're only in the table of contents, so it doesn't have to make sense yet. Then Sam Ingham, they're going to argue, cannot be entitled to a rule that he is the exclusive source of information on the context of pleadings or otherwise. So they're basically saying Sam is trying to make himself some type of exclusive source, and that's just not going to work. And I don't know what they mean, exclusive source. I'm sure we'll get to it in their argument. So then after their introduction, they're going to argue that Britney's out-of-court statements offered for their truth are barred, and so they're not admissible. So basically, Jamie's lawyers are saying anything that Sam said, and this honestly, if Lisa is here, you can actually, Spears Ritual, you actually can have triple and quadruple hearsay. It's actually insane. But Lisa McCarley, if she's here or if she ultimately does arrive here, because sometimes she likes to pop in, I really hope she does, she said this was going to end up being a problem. She did predict this because Sam Ingham, Britney's lawyer, should have offered what's called an affidavit or a declaration and had Britney actually sign it. But he didn't do that. He just said, well, Britney says this, Britney says that. And we were all living for it and loving it and all of that. But I think it's possible that he might have messed up by not writing a declaration. And that's what we're going to get into on this argument here. So right here, they're saying exactly that Britney's out-of-court statements are being offered for their truth, and they are barred by the hearsay rule. And then they're going to use three little, pillars to support their argument. And that's going to be the unverified opposition, which is just a document. So the unverified document contained multiple hearsay statements. And if y'all remember that, no, I think Spears Ritual, it is too late to get a declaration for that opposition. If y'all remember the opposition, it was the very first sassy document that Sam wrote, and we were all living and loving and like, oh my God, Sam got a writing assistant and he's doing his job now finally. The very first one, that was an opposition. That was an opposition to Andrew Wallet. It was opposition to a motion to seal, right? And it did say, far from a conspiracy theory, Britney welcomes the support. It was the one with the page 6 article attached and all that. They're saying that contained multiple hearsay statements. And they're going to also use this little pillar to support their argument, that a lawyer's argument is not evidence. So Sam's argument is not evidence as far as evidence rules in court are concerned. They're also going to argue that out-of-court statements offered for their truth are hearsay. Now, where I went to law school and learned how to write, you would put that one, if you're here learning how to write a legal brief, you always want to put your conclusion first and then last again. So out-of-court statements offered for their truth are hearsay. She should have defined hearsay at the very beginning of the argument, but that's just me being nitpicky for those people who are here for writing. Then C, an attorney's right to speak on behalf of his client is not unlimited. So they're saying, yeah, Sam Ingham had the right to speak on behalf of Britney, but even that is subject to some types of limitations. And then for that argument for support, he's going to say they are going to say Britney doesn't lose her right to speak merely by the existence of this conservatorship. Oh, well, that's rich, because as soon as she does speak, they're going to say that she's not qualified or competent to talk. They're going to also say court-appointed counsel, which is Sam Ingham, is not the exclusive source of information regarding what Britney wants. So I can't wait to read this argument. And they're going to say that Britney has a First Amendment right to be heard. Now, this all is going to sound scary and big and bad, but listen, every single day, very competent, very capable people do not want to be heard in court. They do not want to stand up and testify. They do not want to speak in court. It has nothing to do the fact that, Sam is speaking for Britney. Britney could not want to speak. It could be possible that she wants to be heard through her lawyer, and that's perfectly acceptable. But let's see what their legal arguments end up being. Okay, so what we're looking at here is table of authorities. This is just going to tell you like all the cases that they're going to rely on. And actually, for once, You're going to see them rely on conservatorship law, which I haven't seen them do before, except for LPS conservatorships, which this isn't one. They're going to rely on a few statutes. Oh, yep, LPS conservatorship. This is not an LPS conservatorship, and they are citing the LPS Act, which I think is funny because we could petition to get this thing, lowered to an LPS conservatorship, which would give them a lot less rights. Okay. All right, let's get started here. Conservator of the estate, Jamie, respectfully submits the following brief requested by the court following his evidentiary objections to statements. Okay, so basically what this is saying is, last time we were at a hearing, we made some arguments that this all was hearsay and it shouldn't be allowed in court. And then the court said, okay, well, write me a whole, legal brief about it and convince me with a legal argument and let me read it, and then I'll make a decision. So that's what we're going to be reading right now. Okay, here we go. Whew. Free Britney 11, LPS is for mental illness, which is not the case. Yes, okay, let me clarify really quick, because you are right. I am not saying that Britney Spears qualifies for an LPS conservatorship by virtue of her perhaps existent, perhaps non-existent mental illness. I do not know any diagnosis that Britney Spears has. So it is probably the case she doesn't need to be in any conservatorship. However, if she were in an LPS conservatorship based on mental illness, she would not be in as strict of a conservatorship as she is in now. So let's say they wanted to just bit by bit walk down from this conservatorship, and they didn't want to go full-fledged, like straight to freedom. LPS conservatorship would at least give Britney a little bit more rights, but I do agree that we do not know if Britney does qualify for an LPS conservatorship, and in fact, she probably does not, just based on what we can observe. She can memorize this complicated choreography and lyrics to songs and sing and dance for night after night, night after night, day after day. So I think, it's pretty safe to say that she's not so bad off that she needs to be conserved. But, again, none of us actually really know. That's just my opinion. All right. And I am not a doctor. Okay. So here we go. Introduction. On September 9th, 2020, that was this year, Jamie, conservator of the estate of Britney, submitted objections to certain portions of this document. Okay. So what document was that? That was Britney's opposition to Jamie's motion to seal. That was the one with the page 6 article that said, lock up Lou, jail Jamie, free Britney. It was that scandalous, scathing, right? They're still arguing about that particular document. That's what we're talking about here today. Law students are taking notes from her too. Yeah, no, there are some. The judge might throw this brief out, right? Because they're addressing the wrong type of conservatorship. Her father is a piece of work. Why can't Britney just speak? Yes, she is. Just answering someone. Oh, okay. Free Britney 11. Sorry, I only see some comments that y'all make because I'm reading a lot of other things. So okay, I got it. Yeah. So if I'm explaining over and beyond what y'all meant, it's either because I'm explaining for everybody else or because I just misunderstood what you were saying, and that happens a lot. I really don't mean any offense by it. I'm kind of going on the fly, so sometimes I do mess up on what y'all are saying. Okay. Hope conspirators remember how to make big barbecue. It's so funny. Okay. All right, let's get back to this. All right, so remember that scandalous, scathing document. We all loved it. Probably to this date, one of our favorite ones ever, because it was the first one where Sam kind of went off. We're okay, who helped him write this? So I'm going to stop reading comments for a minute just because I want to get through some of this. But I definitely want to talk about Billy B's comments and all of that stuff. Colin Spears, is that what y'all are calling? Oh my God, stop. Okay. So let's just start over again. Okay. So on September 9th, Jamie submitted some objections based on evidentiary rules to portions of that scathing, scandalous document that we all love. Okay. At the hearing on October 7th, Jamie withdrew his motion to seal, right? So if you remember, that original scathing document was in opposition to Jamie's motion to seal. But they're saying, well, listen, how are you going to oppose a motion to seal when we withdrew that motion? That motion doesn't even exist anymore. However, the court requested briefing based on 2 different subjects, although not directed at any currently. Okay, so they're kind of being sassy to the court. They're saying, okay, well, he withdrew his motion to seal and those evidentiary objections, but the court still wanted us to I guess address it for whatever reason, you dumb court. So I guess here's your dumb thing. That's kind of what they're saying. The first thing that the court wanted addressed is quite straightforward and specific. Okay, what was that? That was whether allegations that Sam, who's Britney's lawyer, made in his opposition, which is that document, and other allegations that he made in his sorry, whoops, I messed up. This is all one sentence. It's long, and even I get confused. Okay. The first subject is quite straightforward and specific, but I couldn't even figure it out on the first reading, so I guess it's not that straightforward. And that was whether allegations that Sam Ingham made in that opposition were inadmissible hearsay. Okay, so that's the first question. If what Sam said in the opposition is inadmissible hearsay, so that's what we're going to be getting into as the first issue. And this is going to be very legally complicated. If you're just here to look at, what's going on with Britney and her court, this is kind of in the weeds legal stuff, and I'm really happy that a lot of people are here. But if this is boring to you, please, you're not going to hurt my feelings if you don't want to deal with it. The second issue that they're going to address is less straightforward. And its purpose appears to be to set broad brush, general ground rules for Sam Ingham's pleadings going forward. Okay, so the second issue that the court requested a briefing on is going to be for a specific purpose. And the purpose appears to be to set some ground rules for what Sam Ingham's pleadings, which means his legal documents, can say in the future. Whether this court should determine that Sam Ingham is and shall be the exclusive source of information on Miss Spears' opinions and pleadings. So this is the question they want an answer to, Geraldine. Whether this court should determine that Sam is and shall continue to be the exclusive or only source of information about Britney Spears' opinion. Now, here's Jamie's lawyers. This is not law, nor does it provide the constitutional safeguards to which Miss Spears is entitled within the context of this conservatorship. So they want to worry about I always love when they all of a sudden are aware of Britney Spears' constitutional rights, because they did not give a flying rat's bleep about her constitutional rights whenever they infringed upon them with, they completely aided and abetted the courts of California in infringing upon Britney Spears' constitutional rights to equal protection under the law, to due process, under the 5th and 14th Amendments. They didn't care about her constitutional rights to be heard whenever she nominated Bessemer Trust. They didn't care about her constitutional rights pretty much to see her children, to cohabitate with her children. They didn't care about her constitutional rights to speak with who she wanted to speak with on a day-to-day basis. I could quite literally go on for 10 minutes about all of the constitutional rights that they haven't given a flying rat's ascot about. But now they care about them, and I think that's really adorable. All right. Moreover, there is no petition or motion pending in connection with this issue, as Jamie has withdrawn his motion to seal. Okay. So basically, this is the overlying backdrop of what we're dealing with here is that there was a motion to seal records filed by Jamie. Okay, Jamie Spears filed the motion to seal, which means the motion to keep everything out of the public eye. To that motion, which is like a request, Sam Ingham, which is Britney's lawyer, he filed a reply. And he said, no, I object. Nope. We're not going to seal anything anymore. And then they went back and forth on that. But on October 7th, Jamie Spears said, okay, you know what? Never mind. Screw it. Just screw it. I'm not doing it anymore. I'm just take that piece of paper, remove it. There's no more request for a motion to seal. Jamie doesn't want the motion, doesn't want anything sealed anymore as far as this is concerned. And now Geraldine and Gerald, who are Jamie's lawyers, are saying there is no petition or motion to seal pending here. But Sam Ingham has come out and said, you know what? I want the judge to tell me, am I allowed to speak on behalf of Britney or not? If I'm not, let me change the way I'm doing things. So Sam wants some direction from the judge. And these people are saying, well, I don't know why he just wants these broad brush rules. It's so weird. That's kind of what they're miffed about. Britney Army 101, we are in a classroom, guys. Yeah, I'm the teacher. That's so funny. You're right. Okay, so during the course of the hearing on the motion to seal on October 7th, so that was the most recent hearing that we knew about. Actually, I think there was one on the 14th about accounting or something. So there was this hearing on the 7th, and during that hearing, this court stated in pertinent part. Oh, we're getting a quote from the court. Ooh, goody. The court said this during the October 7th hearing. It said, ahem. There will likely be other pleadings that Sam Ingham is going to file, in which he may provide statements in there that his client has made, where there's no declaration by Britney, okay? Such that the situation has occurred with the other motion with her again. So the judge is saying, okay, yeah, y'all withdrew your thing on this one, but it could happen again. And the court says, Sam's argument is that Britney doesn't have the capacity to do it. And so there's a way to try to resolve it through briefing. And briefing means they each write a competing one of these things we're reading right now. It may or may not resolve it, the judge said. Maybe it won't. I don't know, because it's not before me yet in terms of the information that I'm going to get. So that's what I understand the concern to be. So they're saying that's what the judge said. And that was from October transcript, page 27, lines 18 through 28. So what does that tell us? If you're here for learning how to read legal documents, that tells us that we have a transcript out there that's at least 27 pages long. And ooh, would I love to get my hands on it. Okay. Here's their first part of their argument. Sam's unverified statements attributing statements to Britney are not admissible because they're double hearsay. Sam's position on the first issue of whether Britney's okay, so now we're on the first issue, whether Britney's statements are inadmissible hearsay, right? So they're saying Sam's position is based on a false premise. There's no ruling in this matter that Britney lacks all capacity. Okay, so I like that they said that. There is no ruling, and Sam's going to be able to, and Loeb are going to be able to use this against them later. There is no ruling in this matter that Britney lacks all capacity. Nonetheless, Sam Ingham has claimed that this is Sam Ingham's claim. Larger issues I am interested in as to whether my client has capacity to execute a verified declaration for any purpose in this case. Okay. And so, that is the issue. I believe that she does not have the capacity to execute a declaration for any purpose. Okay. A lot of people might have gotten mad at Sam for that and said, oh, Sam believes Britney doesn't have the capacity. Sorry, I needed to adjust my position. My foot's falling asleep. I'm in my beanbag chair here. Okay. But don't get mad at Sam because that is not necessarily what that means. What it could mean is that it is Sam's understanding that Britney does not have the legal capacity to execute a declaration for any purpose. Okay? Then Sam said, if his client, who is Britney, is not legally capable of executing a verified declaration because she lacks capacity, and that could mean legal capacity, right? It doesn't necessarily mean that Sam agrees that Britney doesn't have capacity. It just means legally right now in the world we live in, she doesn't have legal capacity. She doesn't have medical capacity. She has 2 conservatorships over her person and her estate, right? So Sam had said, if Britney is not legally capable of executing a declaration because she lacks capacity because she's under conservatorship, then James's objection is inappropriate. Okay, so just to reiterate again, y'all, hearsay is an out-of-court statement made, which is offered as a true statement in court, okay? So Sam Ingham is saying, pardon me, strike that. Okay. So hearsay, out of court statement used in court as if it's a true statement. But if you have something called a declaration right here, or an affidavit that is signed under penalty of perjury, it makes that evidence a little bit, it makes it a little bit more like evidence and a little bit less like hearsay. Now you do, in order to completely get over the hearsay bar, if you're here as a legal person, you do have to make that particular person available to be cross-examined, whether that means on the stand at trial or in a deposition. However, if they do, under penalty of perjury, a declaration, which is this right here, then, and they make themselves available to be cross-examined, then to my understanding of evidence, which is not a lot, then that would make it a little more like evidence and a little bit less like hearsay, which would allow it to be admissible in court. Okay, if that makes sense. If it doesn't, sorry, I did the best I could. Okay, so basically Geraldine and Gerald are saying, but the court never ruled. Jamie's lawyers are saying, there's no ruling in this matter that Britney lacks all capacity. Okay. Which is good. I mean, I think they're stupid for making this argument because we're just going to use it against them. We could put this on a billboard. There is no ruling in this matter that Britney lacks all capacity. And here comes Sam, whether he's dumb or not, he's in here going, well, she lacks capacity because she's under conservatorship. So she can't do this declaration crap. How's she going to be penalty of perjury, make herself available for a declaration and all this whenever they're saying she can't even goddamn nominate a trustee? If she can't do that, how can she file a declaration? That's Sam's argument. And Geraldine, Jamie's argument is, well, the court didn't say she lacks all capacity. Maybe she can sign a declaration. So Sam's saying, you know what? Fine. Court, you tell me. Can she do a declaration or can she not? Because there's some things that I'm going to need her to attest to. So either I'm going to get to say it or you're going to have to let her sign a declaration. And Jamie and Geraldine and them were like, oh, haha, let's not let the court decide this. Let's withdraw our motion to seal. Then it'll make it unnecessary for the judge to make this. Right? It's all just playing chess. It's all just stupid strategy to avoid getting to the merits of the substance of the case. So now the judge is saying, no. Y'all need to write me a brief and I need to know what y'all's arguments are. And this, what we're reading right now as we speak, is that brief that the judge asked for. Confused, mystified, and perplexed. I'm sorry, y'all. I'm sorry. I really am trying. Maybe if I just keep going over it more, it'll make more sense. Okay, so now Jamie's saying, Sam's statement is that, so Sam Ingham's statement is that sassy ass opposition is a verified pleading. And the fact that he's saying it's a verified pleading is not true. So they're going to argue that a lawyer, there's no verification or declaration under penalty of perjury. Do y'all remember whenever I said the thing about if you go under penalty of perjury and all of that, then that can be evidence, kind of. They're saying, no, he didn't do a declaration or verification under penalty of perjury at the end of his document, and therefore it's hearsay. Okay, so hearsay evidence in the state of California. Evidence of a statement that was made other than by a witness while testifying at a hearing, and that is offered to prove the truth of the matter stated. Okay, so that's pretty much what I already told y'all it is, right? So evidence, hearsay is evidence of a statement that was made by someone who was not testifying at a hearing, right? This is just out of court. And that is offered to prove the truth of the matter that is stated, right here. That is offered to prove the truth of the matter that is stated within that hearsay statement. Okay, so here, the thing that they're probably mad about is, for example, that that Sam said, Britney believes it is in her best interest to make these hearing notes public. Okay, do y'all remember whenever Sam said that? Geraldine and Jamie are saying that's hearsay. And Sam is saying, even if it is hearsay, How the F else are we supposed to get Britney's words into a court of law? If y'all are saying she can't even freaking nominate Bessemer Trust, how are we supposed to, in good faith, believe she can testify under penalty of perjury? And if Britney can't testify under penalty of perjury, that must mean that the lawyer is allowed to say it on her behalf, if you follow that argument. If that makes sense. Jamie is running out of fuel for his little lamp. Lawyers ain't got a clue. I know. So basically, Geraldine and Gerald are saying that Britney can't speak for herself through a declaration because she doesn't have legal capacity. She can't speak through her lawyer because it's hearsay. 100% right, Leanne. Okay, Leanne has... Perfect. Leanne, you're going to be a lawyer if you're not already. Like, you're so good at this. Leanne Simmons said, Britney can't speak. This is, basically she's Leanne's implying this is what Geraldine and Gerald, Jamie's lawyers, are saying. Britney can't speak for herself through a declaration because she doesn't have legal capacity. And she can't speak through her lawyer because it's hearsay. Bullshit. Exactly. So what Leanne said is basically the catch-22 that we are caught in. Either, like, somehow, some way, shape, or form, Britney has to be able to speak. And if you're telling me that she, is incapacitated, that must mean that she can't do a declaration. And if she can't do a declaration, that must mean her lawyer can talk for her. Because if even her lawyer can't talk for her, who the hell can talk for her? And if you remember, Geraldine and Gerald have also said, oh, well, Jody Montgomery gets to assert her right, and, we get to assert her right, and Sam gets to assert, basically Sam Ingham wants it settled once and for goddamn all. Who gets to speak on behalf of Britney Spears, and what does he need to do for it to be acceptable to the court? And you know what? Maybe he should know this already, but I agree. I would like a straightforward answer from the court. And now this, what we're reading right now, is Jamie Spears' lawyer's argument as to why Britney should be allowed to sign a declaration or something. The hearsay argument. LOL, how is it hearsay to talk to my lawyer? Yeah, that's a great question, Free Britney 11. I actually don't know. I don't think it doesn't make sense to me. It doesn't make sense to me why it is hearsay. I mean, it is an out of court, okay, playing devil's advocate for a second. Y'all don't come for my neck. This is what you have to do as a, law student and a lawyer. Yes, you can go to the bathroom, Britney Army 101. What the fuck? You're so silly. Okay. So basically what's going on here is, the court Jamie's lawyers are making their argument as to why, Britney Sam should not be able to speak on behalf of her. And we're going to see what the court has to say, because if it was such an easy thing to figure out, I think that, Leanne coming through with a hot question again. Why can Weil and Cohen speak for Jamie Spears, but Ingham can't speak for Britney? That's another good question. I mean, I really don't know. Out of court. So yeah. Britney V's life. Thank you. That helps my train of thought get back on. Out of court statements are hearsay technically. Britney V's life. That is correct. So even though the lawyer it is her lawyer, and maybe they did speak on certain things, technically, if he's saying, oh, Britney made the following statement, and I'm telling you, the court, that it is a true statement, technically, I mean, that is hearsay. But we're in a weird situation of a conservatorship where Sam, probably in good faith, believed Britney couldn't file a declaration. So he's kind of saying, you know what, then what am I supposed to do? And this is, Jamie's lawyers' whack at what they should do, I guess. Okay. So here's more evidence rules. Except as provided by law. Remember those exceptions I told y'all about? So unless an exception applies, hearsay is inadmissible. Statements. Okay, so what's a statement, right? Hearsay evidence is a statement that was made other than by blah, blah, blah. Okay, what is a statement? A statement is an oral or written verbal expression or nonverbal conduct of a person that is intended as a substitute for an oral or written expression. So that's like nodding your head or shaking your head back and forth or pointing to something, Conservatees, such as Britney Spears and their counsel, are not expected from the application of accepted. Conservatees and their counsel are not excluded pretty much from the hearsay rule. So basically they're saying hearsay rule still applies to conservatees like Britney and Sam. The hearsay rule applies equally to their statements, as to the statements of any other interested person in a conservatorship. Okay, so they're saying there's no special relationship. What I find interesting here, and maybe they make this argument later, they don't cite any case. The hearsay rule applies equally to their statements as to the statements of other interested persons in a conservatorship. Usually you would want to see some citation here. Why do they think that? Because it is unlikely that the hearsay rule of the state of California says the hearsay rule applies equally to their statement. Like, I would like to see a citation there. And the reason isn't just to be nitpicky. The reason is I'm not sure this is true. I don't know. The court could have decided the hearsay rule doesn't apply equally, right? They could be wrong on this point. And if that is the case, then it would change the outcome of this hearing, right? The probate code's incorporation of the hearsay rule is underscored by probate code section 1022. Oh, thank you. Here's a citation. An affidavit or verified petition shall be received as evidence when offered in an uncontested proceeding under this code. I don't understand what their point is. An affidavit shall be received as evidence when offered in an uncontested proceeding under this code. I don't understand what their point is. All they're saying is that the probate court uses the hearsay, but the probate code applies to things beyond conservatorships. Like there's probate for estates and trusts and stuff like that. So, no, not trusts. I think the whole point of a trust is to keep it out of probate. Don't quote me on that. I guess they're just saying, the probate code incorporates the hearsay rule, so that must mean that Britney should sign an affidavit. I don't think this is a strong argument. I really don't even honestly get it. So, I love this class. They just announced some kind of boxes with t-shirts and my 2021 boxes. Ew, I could not care less about those boxes. Okay. Next argument is Sam cannot be entitled to a rule that he is the exclusive source of information. Okay. So Sam's position on the second issue. So the second issue is who's the source? What about the source of that who's the source of Britney's opinion, right? Mr. Ingham's position on that is the following, and this is a quote from him, from Sam Ingham, said the following. And so it is my viewpoint that I am the exclusive source of information in the context of public pleadings anyway, as to what my client wants and what my client's position is. So if I, this is Sam Ingham talking, am going to receive an evidentiary objection every time I make an assertion as to what my client believes, I think it will indeed have an impact and cast a pall over every other issue that we are dealing with in this case with regard to the appointment of... Okay. So this is basically saying what we already established. Listen, if every time I'm trying to say something Britney said, I'm going to get an objection on evidence grounds, it's going to really, really make us kick the can further down the road every time something comes up. And I'm not playing that. So please, Judge, Your Honor, please tell me, what am I supposed to do? But he says, I would suggest this is not a hearsay issue at all. Because he's saying every time I make an assertion as to what my client believes, then I think it will indeed have an impact and cast the pall over every other issue that we're dealing with in this case with regard to the appointment of a new conservator. And so I would suggest it is not a hearsay issue at all. Okay, so what does Geraldine think? Geraldine said, Sam inappropriately equated his duty and ability to act as an agent and advocate for his client. So basically, Sam got it wrong. He's ignoring the rules of evidence, and he's depriving Britney of her constitutional rights of freedom of speech and right to petition, which, Jesus Christ, I can't believe these people are really, honestly, even fooling around typing about her constitutional rights. This is just abhorrent. However, nothing in the probate code deprives a conservatee of the ability to have her voice heard. I'm going to use this against them. Somebody put this on a poster. It's too long, too. Nothing in the probate code deprives a conservatee the ability to have her voice heard. in relationship to her own conservatorship proceedings. Ooh, what a good sentence. Ooh, put it on a shirt. Especially whereas here, there's no factual finding that she lacks the capacity to express herself. This whole thing might have just been Sam trying to lure them into making this argument so he can use it against them. There is no factual finding by this court that she lacks the capacity to express herself. So what does this mean if we're thinking about this from playing a game, nothing's too long for a poster, of chess? What we're thinking is this is setting them up to be able to litigate or go to court and have a trial over whether Britney lacks the capacity to express herself, okay? We already know that they're going to argue about that. Sam's position is that because Britney is the subject of a conservatorship, that she lacks all capacity. He argued on October, okay, so this is actually transcript of the proceedings. So this is what Sam Ingham said in court. He said, it is obvious, self-evident, that Britney can't file declarations that are verified because she lacks the legal capacity to file declarations. One has to look no further than the conservatorship of Linland, which is some case that he was citing, to understand that even a comatose conservatee can have court-appointed counsel filing reports and asserting their interest. So remember everybody got all mad. He compared it to a comatose conservatee. Y'all really got mad for no reason. Because he was saying, look, even somebody in a coma, they can have their court-appointed counsel filing reports and asserting their interests. So he was arguing to the court that he should be able to assert Britney's interests because that person was in a conservatorship and so is Britney. But Geraldine said that's not true. No blanket rule says that conservatees lack capacity to make statements under penalty of perjury. So maybe Sam was wrong. I'm not saying he was right. But I'm saying I think we were a little bit reactive to get so mad about that comatose thing. Geraldine said, in fact, during the course of the conservatorship, Britney has testified at deposition and multiple times in court. Oh, well, I didn't know that. Okay, Lisa. Yes, Lisa's here. Thank God. Oh, God. You know evidence is my worst subject. Okay. Lisa said there is no legal authority for attorneys to write reports. Geraldine is right. Okay, perfect. No legal authority for attorneys to write reports. Okay. Yeah, I remember, Lisa, you being adamant when we were reading that opposition that he should have filed a declaration. And I mentioned that, yes, Sam is wrong. No, I want to know what is right. And we need to know what is right, especially because all of these accounts are getting taken down and we need to only say what's right here about the law. So, okay, perfect. All right. Conservatorship may be established where the conservatee is not adjudged to lack capacity with regard to all decision making, as is in this voluntary conservatorship. So this is a fancy sentence that basically says some conservatorships don't determine that the conservatee lacks all capacity for just all decision making, right? And that is the case here, is what they're saying. Which honestly, y'all, like, they're annoying and stuff, but I'm glad they're making these arguments. Because what they're saying is, Britney doesn't lack all decision-making capacity. The court has not determined that. In fact, a lack of capacity is not even one of the requisites of appointment of conservator, of either the person or the estate. Well, that's weird. There's no declaration of generalized incapacity here. And no finding of her capacity even remotely current. Britney retains her right to vote among other rights. They made sure to put that in there because they see us asking it all the time. So here you have it in the court documents, according to them. I'm just making sure Lisa hasn't said anything else. Lisa, anything else? Britney retains her right to vote. So all y'all that asked me if Britney has her right to vote or doesn't, I said in a recent live that she probably actually does still have her right to vote. The issue is probably, if anything, that she perhaps doesn't get taken to the polls to vote or given, her mail-in ballot and stuff. But, I don't know. Maybe they do. Maybe she does. I do not know. That is just speculation. She retains her right to vote among other rights. So there you all have it. That answers that question. If anybody asks if she has the right to vote, according to Jamie's lawyers, she does. Moreover, there is a presumption of capacity to testify unless established otherwise. I am so happy they're making these arguments, to be honest. Leanne said, so Britney can be deposed when it's against Sam Lufty, but not when Lucifer and co are being sued for fraud by Brand Sense. Got it. Exactly. I was just thinking that, Leanne. I didn't want to chase the rabbit. I didn't want to down the rabbit hole. But yeah, exactly. They sure did say that Britney didn't have capacity in 2012 when they got sued for $10 million or whatever it was. Loeb and Loeb needs to take over 100% according to Lisa. I think that's probably right, Lisa, just to make sure CYA insurance, right? Can't drive herself to vote. Exactly. I care about getting things back on track for Britney and what needs to happen. How can a court appointed, I heard my client say, duh, I love the crowd. Okay. Britney is not, Jamie is not stating in a vacuum that Britney must file verified declarations. Sam's ability, oh wait, sorry, I skipped a paragraph. Okay, there's a presumption of capacity to testify unless established otherwise. Except as otherwise provided by statute, every person, irrespective of age, which means no matter how old they are, is qualified to be a witness, and no person is disqualified to testify in any matter. They're going to regret writing this brief. Evidence Code 701 says a person is disqualified to be a witness if she is incapable of expressing himself or herself concerning the matter so as to be understood, or then they'll be disqualified as a witness if they're incapable of understanding the duty of a witness to tell the truth. Contrary to Sam Ingham's assertions, Jamie is not stating in a vacuum that Britney has to file verified declarations. However, Sam's ability to present his case and make representations of his on his client's behalf is not unlimited. So they're saying he has limits to what he can say on her behalf. California law permits him to make admissions and to take positions on behalf of Britney, and as may any counsel representing a client. And he may waive certain of her rights given the safeguards and protections that are built into the statutory structure for conservatorships. But nowhere in California statutes, rules of court, or case law is there a basis for the court to determine that Sam, as Britney's court-appointed counsel, is the only or exclusive voice for Britney, especially where the scope of such a determination is theoretical and potentially unlimited. Okay. I know we hate them, but I think they're right. I think that what they're arguing is Sam Ingham said he was the exclusive voice of Britney Spears and she can't file a declaration. But that can't be true, that he's the only way. Now, that doesn't mean that Sam can't file a declaration. And if Lisa is here, let me scroll. Geraldine is sadly right. Sam is about to get his head handed to him. Okay, perfect. Wonderful. So I just won't even say what I was about to say. Britney retains her right to be heard. She is presumed to have capacity unless it is established otherwise. Further, whether an individual, and honestly, y'all, this makes Sam look, sorry, I had to readjust. It makes Sam look pretty bad because he should have just filed a declaration. And honestly, I have to give it to Lisa. She did say this from the very beginning. She really did see the writing on the wall with this. And now it is going to come back. And honestly, I think Sam just does need to hand the reins over to Loeb and Loeb at this point. Further, whether an individual has capacity is not subject to an either-or analysis. An individual may have capacity for some decision-making, but not for others. Under the Due Process and Competence Act, they should have never gave me this. Somebody write this down. Due Process and Competence Act and send it to me via DM. Sam should never be writing reports. This makes Sam look bad, Lisa said. What did Harry Gibson say? We have to deal with the election and Britney's hearing 7 days apart. Make sure y'all have your alcohol on deck. That's so funny. Somebody please, screenshot this or send this to me. Due Process and Competence Act, Probate Code, Section 810, California. I want to look it up. Okay, it says mental capacity can be measured on a sliding scale, with marital capacity requiring the least amount of capacity. Why would they put that in there? Followed by testamentary capacity. Marital capacity has the least amount of capacity. This is huge, y'all. This is huge. And I know Lisa already knows this. But everyone else, y'all, There's a Due Process Incompetence Act. They have told us that Britney's competency hearing determinations are really out of date. They have also told us that this act says that mental capacity is measured on a sliding scale, like a spectrum of sorts, right? Marriage capacity is the least. It's the bottom. So they're basically handing us an argument on a platter to allow Britney to get married if she wants. And listen, I'm not even really a Sam fan, to be honest, but if she wants it, the whole point is it's her choice. It's her body. It's her choice. It's her life. The next thing along that sliding spectrum scale of capacity is testamentary capacity. Lisa said at $10,000 a week, Sam should be well equipped to litigate for his clients. I agree. No argument there. And on the high end of the scale is the mental capacity for contracts. So that's them telling us they're going to argue that Britney should not be allowed to enter into contracts. They're not going to say it in this document, but I'm just telling you, like, they're teeing us up and giving us foreshadowing. It is Britney and not her counsel who has the right to determine when she wishes to be heard and when she does not. I agree with that, and I think they're right on that. And we should all agree with that, because it is true that we should want Britney to have the most rights. Glad Sam's helping, but he's going to go down. That's why he stated Loeb and Loeb not have contact with Britney. He wants to control it, and he played a part in getting Adam Streisand thrown out. Sorry, fam. Yep, well, listen, it is what it is. I can't argue with that. All right, next thing. And I might even this might be the first time ever that we actually run out of time in the middle of a document. Britney Spears' out-of-court statement is offered for their truth, and therefore it's barred by the hearsay rule. The issue to be addressed by the court is whether Sam Ingham can submit out-of-court statements of Britney in court documents for the truth of the matter that those statements actually assert. This requires a simple and straightforward hearsay rule analysis. The foundational question, so you have to ask one question first, and that's, what is the purpose that the court statements are offered? If they are offered for another purpose other than the truth of the matter, right, like to show her state of mind or something like that, then they're not hearsay, right? But if they are offered to assert the truth of the matter that they contain in them, then it is hearsay and it's inadmissible unless an exception allows them in. Okay. Hearsay evidence is evidence of a statement that was made other than while you're testifying, right? That's offered to prove the truth of the matter stated. Number one argument, the unverified opposition, that's that document, contained multiple hearsay statements. As are detailed in Jamie's evidentiary objections to that sassy document Sam filed, a number of factual statements in the unverified opposition were unsupported by any declaration. So they're saying, look, no declaration. Here's the statements they don't like, okay? Here's the hearsay they don't like. First of all, moreover, Britney strongly believes it is consistent not only with her personal best interest, but also with good public policy, that the decision to appoint a new conservator is open and transparent. They didn't like that. They didn't like that Sam said the sealing motion is supposedly being brought by her father to protect Britney's interests, but she is adamantly opposed to it. So saying that she's opposed to the hearing motion. Let me see if Lisa said anything. Okay, Lisa said there is no hearsay exception for court-appointed attorneys. Okay, perfect. Thank you for clearing that up. I agree, Lisa. Okay. All right. The other thing that they call it hearsay. Whatever merits Jamie's strategy might have had years ago when Britney was trying to restart her career, at this point in her life when they said this wrong, it's supposed to be she is trying to regain some measure of personal autonomy, Britney welcomes and appreciates. Oh, they're calling this hearsay. Britney welcomes and appreciates the informed support of her many fans. I hope she files a declaration saying she does. Although the sealing motion, which was Jamie's motion to seal, is supposedly for Britney's protection, Britney is opposed to the effort by her father to keep her legal struggle hidden away. So they're calling that hearsay as well. I know, I do need water. Okay, a lawyer's argument is not evidence. Because the lawyer's role as authorized representative for the client, a factual statement in a pleading may be admitted into evidence giving a client as admission, which is an exception to the hearsay rule. But the evidence code does not contain any exception to hearsay for out-of-court statements of the conservatee when offered by her own lawyer for the truth of the matter asserted. Because Mr. Ingham's retelling of Britney's out-of-court statements are offered for their truth, they are inadmissible hearsay. They don't offer any real case law to support this. They don't, like, if Lisa wasn't here, I would be saying, like, where's their support for this? Where's their case law? I need an analogous case. But Lisa is here, so I am going to say that this argument is probably right, because she has seemed to have agreed with it. Okay. Third argument here. Out-of-court statements offered for their truth are hearsay. See, this should have been just from a purely, like, Lisa said, speaking directly to Britney, I suspect Sam is a little worried about what Britney will say. Oh, okay. Okay. If the out-of-court statement is offered for the truth of the matter asserted, then those statements are subject to the hearsay rule and are inadmissible unless there's an exception. Now, what I do think is going to happen is Sam is going to give a good, Lisa said Geraldine's evidentiary objections are right. Sam is going to try his best to make an argument that these statements are some kind of exception to the hearsay rule. He's going to try to say that Britney was incompetent to file a declaration, but that's going to probably fail for two reasons. First of all, legally, I just don't think that's the case, especially according to what, Lisa is saying. And second of all, he has already had Britney sign declarations in this exact case before, and I hope Geraldine and them are smart enough to figure that out. Any out-of-court statement, no matter how presented to the court, is inadmissible hearsay if offered for the truth. See how they put a case citation here? Any out-of-court statement, no matter how it is presented to the court, is an inadmissible hearsay if it is offered for its truth. Hearsay evidence is generally incompetent and inadmissible without some other exception or or without a stipulation or a waiver. So unless there's a waiver or an exception, hearsay is not admissible. In the context of proceedings under this probate code, section 1022 limits the use of affidavits and verified pleadings. In the context of proceedings under the probate code, section 1022 limits the use of affidavits and verified pleadings as evidence in uncontested proceedings. Okay, so there are some limits, right? Establishing facts may not be considered as evidence. Affidavits and verified petitions may not be considered as evidence in a contested probate hearing. But I think they're arguing this is uncontested. Is the screen not bright enough? Yeah, that's as bright as it goes. Sorry. Doesn't go any brighter. Maybe I have to clean my screen. Okay, this rule is inconsistent with the long established. Okay, each allegation in a verified petition must be established by competent evidence. I don't really know what they're trying to get at here. And this rule is consistent with the long established. This is a contest. That's what I was thinking, Lisa, like, limits the use in uncontested. And they're saying this is contested? Moreover, establishing facts requires more than the word of the attorney. Each allegation has to be established by facts, and they're saying just Sam Ingham's word is not facts. This rule is consistent with the long-established rule of civil practice, that a party is entitled to have received an evidence and considered by court competent, relevant, and material evidence. Another court had said it was an abuse of discretion to deny a request for an evidentiary hearing of a contested motion. Hold on a second, the Bennett court pointed out that because the hearing was contested, the parties could not proceed on this. Yeah, we're getting like really in the weeds here. Let me think. This is contested. Sorry. No, stop, cat. Let's see. California Supreme Court analyzed the admissibility of Conservatee's hearsay statements contained in the initial investigator's report. Finally, they're getting into some case law here. And what did that court say? The court concluded that the admission of the report at the contested trial was in error, in part because there was no exception to the hearsay rule. So basically, okay, honestly, this is good. This is good. I know the cat, she's annoying. This is good legal argument And they're right. So the California Supreme Court already looked at this case, at a similar case before, and they thought about the admissibility of hearsay statements of a conservatee contained in the investigator's report. And the Supreme Court said that to admit that report at a contested trial was erroneous. They should not have done it. And one of the reasons why was because there was no applicable exception. Okay. It makes it clear that the rules of evidence, including the hearsay rule, are not suspended in the conservatorship hearing. Okay, so they did. Oh, only have 13 seconds remaining. Oops. So I guess we're gonna just have to finish on the next live. Go to the next one.